1906. A group of 4 British soldiers hunting pigeons in an Egyptian Don Shway village accidentally shoots the grain trough of Abd al-Nabi, one of the villagers, burns the grain trough, and shoots his sister-in-law Muhammad, who falls instantly. They are protected by the Khafars, the interior policing system of the village. However, they assume the Khafars are attacking them, so they shoot intentionally the head of the Khafars. The villagers attack them with sticks and stones. One of them escapes at a 42 degrees Celsius temperature and dies of a heat stroke. This was the testimony of the British doctor who was called for in the trial of 55 Don Shway villagers ordered by the honorary award English consul in Egypt, winner, Lord Cromer, and according to a decree crafted by himself in 1895 of a special court military-like system. Advertisements are published all over Egyptian newspapers asking whoever can provide flogging machines and execution machines to send them as quickly as possible to Don Shway 10 days before the trial even starts. The trial results in the execution of 5 villagers. One of them, Muhammad Zahran, this one, and this is his family right after the execution. The flogging, 50 flogs each for a number of villagers, and the mix between flogging and imprisonment for others. Few were acquitted. This incident caused a backlash in both Egypt and in UK. In Egypt, a number of Egyptian lawyers led by Mustafa Kamel called for the end of the British occupation. In UK, Wilfred Blunt and Bernard Shaw, the famous writers, have you heard about them? And Tom Dillon, the UK parliamentary politician, asked about the UK parliamentary hearing on Don Shway that results in Lord Cromer returning back to UK, however, greeted warmly as an imperial hero. The reason why the narrative takes most of the presentation is because it's not just a case study. It's rather the core of the thesis and the methodology. TWAIL, the Third World Approaches to International Law, starts from stories of the Global South and theorize on international law, and not the opposite way around. So I start from the trial of Don Shway documents, the UK parliamentary hearings on Don Shway, the writings of writers who lived through Don Shway, and try to answer 4 research questions. How imperialism employed law as a tool in Don Shway, why are reparations needed in cases like Don Shway, given that international law does not allow reparations for colonial crimes because they happened before international law, does this indicate a colonial inclination in international law? And finally, the real outcome and impact of this research is not about getting reparations back for Don Shway. It's rather a larger project of answering a 4th question that I pose to you all to think about in light of Don Shway tragedy. How can we decolonize international law and turn it to a liberative force that fulfills universality?